As of 11:30 last night, I received information that the ICC prosecutor Bersuda has concluded her preliminary examination against President Rodrigo Roa Duterte for the alleged crime of crimes against humanity. She will now seek judicial authorization from the pre-trial chamber of the ICC to formally conduct investigation against President Rodrigo Roa Duterte. I believe that the decision to move forward into a formal investigation stage is legally erroneous, politically motivated. It is legally erroneous because in the first place, the ICC has no jurisdiction over the subject matter of crimes against humanity as alleged in her information against President Rodrigo Roa Duterte. Secondly, the case, even for purposes of formal investigation, is barred by the principle of complementarity. And thirdly, the investigation is not pursuant or in aid of substantial justice. My first submission is that the ICC prosecutor has no jurisdiction. She alleged in the first instance that the Philippine war on drugs is an instance of a crime against humanity. What is a crime against humanity? A crime against humanity is defined under the statute of the ICC law as a widespread or systematic attack against civilians knowing that the subject of attack are civilians. I will ask the Philippine National Police, when you discharge your obligations under the so-called drug war, did you target civilians? Did you kill civilians willingly because they were civilians? Wala pong intensyon na manarget at pumatay ng civilian dahil sila'y civilian. Kung meron man pong kapatayan na nangyari, dahil ito po ay gumamit po ng tamang pagdahas at tamang puwersa ang ating kapulisan. Pangalawa, meron lang pong limited jurisdiction temporal, rationate temporal ang ICC. Dahil ang sinabi po nila ng ating war against drug is a crime against humanity, yung rationale matériel, yung rationale temporaire is limited to June 30, 2016 until 17 March of 2019 when we withdrew from the ICC. Everything that happened before the President took office and implemented the war against drug and everything that happened after 17 March of 2019 is clearly beyond the rationale temporaire jurisdiction of the ICC. Pero mas importanteng objection po sa gagawing investigasyon ng ICC prosecutor ay dun sa prinsipyo ng complementarity at tayo naman po bilang isang naging partido sa ICC, hindi po tayo sana sumapi sa ICC kung hindi dahil sa prinsipyong ito. Ang sinasabi po na yung prinsipyo ng complementarity, the ICC will not exercise jurisdiction unless the member state is unable or unwilling to prosecute. Kapag sinabi pong unable, ibig sabihin walang estado, walang hukuman, walang pulis na gumagana. It is a failed state. Ang unwilling po is when you have legislation according impunity to an individual. Wala po tayong ganyan sa Pilipinas dahil in the first place, lahat po ng presidente matapos ang kanilang termino, hindi po lahat. Dalawang presidente matapos ang kanilang termino, nakulong. Ito po si Presidente Estrada at Presidente Gloria Macapagal Arroyo. At ang pinaka-importanting punto na dapat maintindihan ng lahat ay dahil gumagana po ang mga institusyon natin dito sa Pilipinas. Meron po tayong independyente, impartial at kompetenteng mga hukuman. Bakit maghihimasok ang International Criminal Court na pinakita na natin na kayang-kaya na mga lokal na institusyon na siyang mag-imbestiga sa mga krimen na ito? Because of complementarity, I am confident that the pre-trial chamber will reject the request for investigation. Pangatlo, it is not in pursuit of substantial justice. Bakit? Hindi na po tayo miyembro ng ICC. Ang karapatan at ang kakayahan ng hukuman para mag-imbestiga upang magsampa ng kaso ay nakasalalay sa kooperasyon ng Estado. Sinabi na po ng ating Presidente, hindi tayo magko-cooperate dahil hindi na tayo miyembro ng ICC. Sasayangin lang nilang panahon, sasayangin lang nilang resources ng hukuman dahil without cooperation from the Philippine state, hindi naman makakabuo ng kaso kung hindi base sa ebidensya na hearsay at galing mismo sa mga komunista at politikong kalaban ng Presidente.